Hi folks, Veronique Malka joining you again, this time to discuss a little further the inside workings of the Hague Convention Treaty and what happens exactly under, in a case of Hague abduction of children. We discussed already the workings of the Hague Convention, that it is a fast process and that oftentimes the courts have to be educated. The treaty itself, the Hague Convention, uses very strong words. It uses words that are extremely obligatory on the court, on the judiciary, on the central authorities. It talks about shall return the child. It talks about must acting promptly. Article 9 says shall address it directly and without delay. Article 11 says shall act expeditiously. It specifically specifies a period of 6 weeks after which time the courts must consider returning the child promptly. The reason for the rapidity, the fastness of this process is because a child can become settled in their environment. If they are moved from their country of habitual residence, obviously a child eventually may have to go to school and integrate in a new system. This can be detrimental to the child and obviously also detrimental to the parent who's trying to secure the return of the child. People often ask me, my spouse left the country with my children. I do not have an order for custody or access. I never went to court. Things seemed fine. We were having issues and we decided to take a break. So she left with the children and now she refuses to return. How long has it been, I ask? It's been a couple months. She was gone for the summer, but now that it's time for the kids to go back to school, she's letting me know that she's not coming back. This is unfortunately a very common scenario. In such a case, again, prompt action is necessary, and that's why the convention is drafted in the way that it is, so that the children, even if they have to commence school in the foreign country, will not become settled in their environment. Most judges will be okay returning a child, pulling a child out of school if it's been a month, 2 months, 3 months, 4 months. We can talk later about how long, when it's been a little longer than that, over a year, what happens, and that's a different situation. But my answer to the person seeking this advice is, you don't need a custody or access order. Very simply put, the convention applies to people who don't necessarily have an order. It applies to anybody who has a right of custody or even a right of access, even if that right has not yet been determined by a court. And as most family lawyers know, parents have an equal right to custody and an equal right to access, as well as an equal right to making the decision about where their child will live, until it's determined by a court that the right should be given to one party or the other. But until then, it's an equal right. Equal parents, child is theirs equally, and therefore you do not need an order to avail yourself of the provisions of the Hague Convention. Again, a right of access is sufficient. So if you have a couple who's already separated and divorced, mother has custody of the children, mother leaves the jurisdiction with the children, father can no longer see the children like he used to. Mother's now moved to Australia. Father used to see the children in Canada, but father can't see the children alternate weekends or even in the summers when he used to see them. The Hague Convention will apply. Again, Australia is a member of the convention, so is Canada, and therefore you have application of the Hague Convention Treaty, and the mother may have to return with the children. There are exceptions in the Hague Convention. Those are important. The exceptions that have to do with a child who is settled in their new environment. Usually we're talking about a year's time. Another very important exception, which is argued and has really created quite a body of case law, is under Article 13 of the Convention. Under that section, it's very clearly stated that if the children are settled in their new environment, and it would place the child in physical or psychological harm, or place the child in an intolerable situation, very, very loosely drafted, we can come back to that, then a court may decide not to return the child. Oftentimes, under Article 13, we hear cases of abuse. We hear a parent saying, I can't return because it will put the child at risk, and it will put me, the mother, at risk. He was abusive. I can't return there. There's a body of case law developed in each country defining what this abuse and what this risk of intolerable harm, as the words are in the convention, consists of. And there are decisions as far up as the Supreme Court of Canada that mark that degree of abuse. The process usually of a Hague Convention can take between 6 to 12 weeks. Again, it depends on the rapidity, the speed of the courts. It depends on the proficiency and the availability of the lawyers. And we really cannot stress enough how important it is to hire a lawyer with experience in the Hague Convention. And we hope for the best in all your dealings with this treaty and in securing the return of your children or in preventing the wrongful removal. Please contact us here at NPZ Law Group. This is Veronique Malka. If you have any issues or any questions in regards to the Hague Convention. All the best.